Well, welcome, everybody. We've got quite a crowd, I think, today, so we're going to give it just another minute or two as people kind of pile in here. But thank you for joining us. I think we'll have a great program, and we're glad to have everybody on board. How are we doing, Chase? Got most of them?
Yep.
All right. Well, let's go ahead and get started. I'm Lyle Hanna. I'm delighted to have you guys on board with us today. HR Crisis Management for COVID-19, Phase 47. How in the world could it be? We're going to talk about OSHA. We're going to talk about this emergency temporary standards announcement that was just made. What is going on with all that? Jim Morris is here with us today. He's going to do most of the talking, but Allison is going to help us with questions, and Autumn and Chase the same. We welcome everybody. We hope you've had a good week. Before Jim gets started, I want to tell you a quick story. Of course, I'm in favor of the vaccine. I think it's a good idea. And I have buddies that work at UK, and UK has started a little test on people, the antibodies test. And so I had the two things I finished in August, but my doctor said I ought to get the third one. So I started anticipating that. And at UK, they'll test to see how many antibodies you have. So they said, Lyle, you get your third shot. Don't let your wife get it. Test 3 weeks. Wait 3 weeks, then both of you test. So we did. We both tested the same time, and I got the results. And 3 other people were in the test that week too. And interesting, my wife had 2,700. That was her number. It's a relative number for how many antibodies she has. 2 other people that were tested that week also had 2,700. One person had 7,800. So quite a few more. Not quite sure why, but I was the only one that had the booster, and my number was 71,000. So isn't that wild that it would go up that much? So if you feel like you're at risk and you might need the protection, that daggone booster might do it. Anyway, let's get on with the show today. We got a lot to talk about. Jim, we're glad you're back. Welcome. Jim has been traveling all over the country. Geez, the points unknown, working with clients and stuff. And
yeah,
we're just glad you're here.
Thank you. So the last 3 times you've had a meeting, I was told Lyle I was in Nevada one time, Minnesota the next, and Idaho the next. Last week when it was decided we needed to do this, I was in Boston. So I just got back on Saturday morning. Tyler's put a lot of this together. I'm going to run the show today. I think he's on here too. I'm not positive, but we're flying by the seat of our pants again because this is coming out hot and heavy. Updates are every day, every minute. Things are changing. So if you will recall, sorry, there's me. Hey. All right. So if you'll recall,
yes, that running from the law is tough, Jim.
Huh?
I said that running from the law is tough. You got to cover a lot of ground.
I do. And I don't run very fast. So, just a little background. I didn't put the screen up here because Tyler had it up last time we were talking with you all. I raised the issue to you of an emergency temporary standard, which probably nobody on this call even knew what it was unless you were in the mining industry, since like 1984. Because the last time it was used was asbestos. The time before that was black lung disease. It's very rarely used. It's a very odd concept. It basically means the federal government in an urgent situation can take action that it typically shouldn't be allowed to take without public comment. It was declared in the end of January. The new administration wanted to use this, and I told you either at the end of January, beginning of February, you can go back and look at it. I said this is not going to be easy. They won't announce it quickly. I'm not quite sure what they think they can do, and once they do it, everybody and their brother is going to sue everybody and their brother. Well, it took almost a year. It took 11 months for them to bring this out, 10 and a half for them to roll out the ETS. ETS came out on November 4th. What exactly does it mean? Well, right now it's for 100 or more employees. So a lot of you might be going, well, I don't need to be on the call because it's only 100 or more and we don't have that many employees. Well, there's a whole lot of bad news tucked into the notes, the comments, and the summary of this ETS that you need to be aware of. As we roll through this, it's probably going to make a lot of you more and more concerned. And I'm not trying to scare you, but this is just the reality of where we are. So let me talk about a few things here. Sorry, I didn't turn on my highlighter first, so give me just a second. All right, so first, you must have all of your employees fully vaccinated or subject to at least weekly testing. That's 1 time per week minimum. This is a floor, and it says so. It is not a ceiling. What does that mean? It means this is the bottom line of what you must do. States can require more, employers can require more, but this is the bare minimum of what you can do. This causes a few problems because everyone considered that this was a January 4th implementation. All the news media is talking about, oh, you have 60 days. This doesn't happen until January 4th, the ETS. They kind of swept it away, and the mainstream media kind of just was like, yeah, no big deal. Big companies, they can all handle this. January 4th, no big deal. It took effect November 5th. You must have all of your policies in effect December the 5th. That affects over 84 million people across the country. The tests or the vaccine must be fully implemented by January 4th. That's the difference here. The January 4th was literally that all employees must be either vaccinated fully or subject to the weekly testing. The rest of this all took effect immediately and 30 days for you to be able to follow certain policies, have them implemented and ready to roll. So a lot of people are like, oh, we got 60 days. No, you had last Thursday the 5th to be compliant, and December the 5th to implement all of the policies required, January 5th to have enforcement of all of those policies. So you're in the middle of a lot of your enforcement right now. So here's what's required. You must implement a written mandatory vaccination policy. You don't try to write your own. You need guidance from someone, your legal counsel, your team, whoever it is. You need to put together a mandatory vaccination policy that complies with the OSHA ETS. Must be in writing, must be distributed, must be put out by December the 5th. You're under now 28 days to get that done. Do not try to do this unless you have the expertise. Don't try to use your general counsel if your general counsel doesn't have the knowledge or the capability to write these policies. That's no slap on anybody. It's just the reality. This thing has teeth. I didn't even put it in here because I didn't want to go through it all. $14,000 per violation. That is per employee, not per day, not per anything, per employee per day, because every single day you have to comply with this. They're talking about massive sanctions on employers, and this could get really bad really quick. All right, employers are exempted from this only if you implement and enforce a written policy requiring full vaccination, or they have to undergo at least weekly testing, and they must wear face masks. This is where the lawsuit comes into play, because this is what I call a scarlet letter. If you're not vaccinated, you're going to have to wear a mask, and everybody's going to know you didn't get your vaccine, which violates your HIPAA, which violates your privacy rights, everything. And that's what a lot of these states are starting to challenge is you can't force people to disclose their vaccination status because it can cause discrimination against them. It's already happening. Take a look at some of the football players, basketball players, and so on that are being outed for not being properly vaccinated and so on. Employees must be fully vaccinated. This is the January 4th date that everybody is jumping on. If you decide to permit testing for unvaccinated, and this is the key too, it literally says you don't have to permit testing. You can fire everybody that's not getting vaccinated. It goes against the EEOC guidance that says you must give them every accommodation possible. So now we have an OSHA ETS that conflicts with an EEOC that says you must give certain leeway. It conflicts with the religious and the disability protections that are available. So this is really hot off the presses, really messy, and there's a lot of things that you're going to see change in the next couple of weeks. It remains in effect for 6 months or until May the 5th, 2022, or unless it becomes permanent. Again, unless it becomes permanent. It says right in the recommendations and right in the OSHA ETS, the intent is for this to become a permanent requirement under OSHA for all employers over 100 people, but it actually gets better. So here's the rest of it. And I just said this part. It becomes a proposal for a permanent standard. The awesome thing is that the discussion time period for the permanent standard ends on December the 5th. So you have 30 days right now to make your comments known about whether you want this to be a permanent vaccine mandate forever for every company that has over 100 people. This proposes to establish minimum vaccination, testing, face covering and this is the concern for the states' rights. I don't want to get into the Constitution and so on, but you've heard me before explain many times, states control. The reason why you have Florida wide open, New York closed, I was just in Boston, masks everywhere, mandatory, you can't walk into any building without a mask. Florida, you walk into a building with a mask and they kind of look at you like you're crazy because nobody's been wearing masks since May of 2020. I don't mean nobody, but you get the difference. The reason being, governors and legislatures of the states control each state. The federal government is set up as a safety net to be there to make sure minimums are met. Wage and hour, safe workplace, Social Security, Medicare, Medicaid. The idea of the federal government was we will provide a uniform defense against external threats. It eventually turned into some social programs, which is how we got food stamps, how we got different things. It's not supposed to be the first step. So this last quote in here is really what's going to cause problems. It was set to, quote, establish or address the grave dangers of COVID in the workplace. That's fine. This one, preempt inconsistent state and local requirements relating to these issues, including requirements that ban or limit authority to require vaccination, face coverings, or testing, regardless of the number of employees. Let me repeat the last part. Regardless of the number of employees. What's tucked into this 100 employee mandate is we are currently investigating the cost of this mandate upon smaller employers with less than 100. We don't believe that this is going to cause a substantial impact, so we probably will change this to be less than 100, not 100 or more. So we have to watch the ETS every day to see whether the OSHA decides to just slip in a, by the way, this now applies to 10 or more, 20 or more, 50 or more. We don't know. This is being rolled out at 100, then it's going to be back rolled into a smaller amount. It literally says throughout that we think this can be implemented across the board. We're still investigating it. So if you don't think this applies to you, number one, it most definitely does. I'm going to get to that in a second. Number two, it most definitely will, because they intend this to be rolled back to smaller companies, not just 100 or above. And this is literally, when they say they're going to, they're trying to preempt inconsistent state and local requirements relating to these issues. Florida has the scientific proof to show they are right now one of the country's lowest infection rates, and they've been open for 18 months straight without any closures. So they have the ability to say, you can't say you want to preempt our inconsistent state rules when our rules are stopping the spread better than those that have mask mandates. So they are the leading state right now suing. Let me walk through some of these. As I said before, it's a floor and not a ceiling. These are minimum requirements. They are requirements and not recommendation. And then it literally says, nothing in this section prevents employers from agreeing with workers and their representatives to additional measures. It does not supplant collective bargaining agreements. That's if you want to call it a dog whistle, that's a dog whistle to the unions that they have the ability to insist on whatever they want, because collective bargaining agreements are unions, workers and their representatives, that is union. So suggesting additional measures and indicating the ability to do that, that is literally an invitation to the unions to mandate more strict requirements than the weekly testing, mandatory vaccinations, and so on. So who does it apply to right now? 100 or more, as I said, with 3 exceptions. One is the healthcare ETS, which takes precedence over the regular ETS. Federal contractors, which were already covered under the announcement I talked to you about back in August. And then this third one is the one that may save some of you, which is if the employees don't have to report to work where other coworkers are present. So if you have a work at home, you do not have to mandate it. It also then literally covers at-home workers and those that exclusively work outdoors. So if you can send all of your employees outdoors, have at it. I don't know, outdoors has not been defined. So I talked about that last January or February, because a lot of the restaurants were having outdoor eating, which was nothing more than a plastic tent with heaters running and people sitting without social distancing. How's that outdoors? So now if you open the window at your office, is that outdoors? Do you open all the windows and have heaters running and now all of a sudden it's outdoors? Now you can have people working, call it outdoors, and you don't have to be vaccinated. I don't know, because they didn't bother to define outdoors. They do say exclusively outdoors, so I wouldn't play games with this, because this is the federal ETS. They are doing $14,000. Is it really worth it to try to challenge them? I would say no. So it applies to employers with more than 100 at any time during the ETS, so between now and May 22nd of 2022. They suggest additional implications are being investigated. This is the part I told you about, beware, because it's not just 100. It actually is less than 100 that they intend to implement. They're still investigating the impact on businesses. This last thing is the thing I think you all need to really think about, because if you have 10 employees, little restaurant, little coffee shop, little law office, whatever, this impacts everything that you order, because it impacts your supply chain, your factory workers, emergency response team, fire departments, police departments, EMTs, hospitals, mail delivery, UPS, FedEx, Amazon, since everybody orders on Amazon, Kroger, everything. Any business that you derive anything from that has 100 or more employees is immediately impacted by this. The problem with that is factory workers are at like 55% to 60% compliance. Truck drivers are at 55 to 60% compliance. Some of your federal or some of your EMT are at 70%, 30% are not getting vaccinated. There's going to be a tremendous impact on supply chain beyond the supply chain problems that we're already having with chips and so on. So if you're not prepared for this, you need to be prepared. Deliveries are going to be slowed. Food deliveries are going to be slowed. Truck drivers are going to be delayed because they're already short supplied. This is going to create a tremendous problem. I would jump on supply chain issues early. Try to stock up on durable goods earlier rather than later, because this is, as this becomes more and more implemented, before January 4th, you're going to see a tremendous drop off on timely delivery of goods. So it affects all of you.
Hey, Jim,
right.
You've got a boatload of questions already. I wonder if you should try to take some of those and then.
How about, I think we roll through it, because I'm going to answer a lot of these as we go, probably. Okay. And then we can do a list of questions at the end, because some of them may be answered on future slides. I've only done the, darn, here's the implementation. Now we're getting ready to explain what it is and how you can handle it. So let's wait on those a little bit.
All right.
And we'll come back to them as best I can, okay?
Okay.
So here we go. Covered employers, you're required to keep a record of vaccination status as well as a roster of each employee's status. Those are medical records. They must not be disclosed except or required or authorized by OSHA or any other federal law, but you are now required to maintain those. My recommendation is put those into a red file like every other. Hold them separate in that red file for OSHA to see, because you really don't want OSHA digging into your other red file documentation, but you are going to have to keep those. You're required to keep those. Here's the awesome part. Then they come back and say, well, but not vaccination records. Well, hold on. You must maintain medical records under OSHA for 30 years plus the duration of employment. 30 years plus duration of employment. Employee's vaccination status is a medical record. It literally says right here, it is a medical record covered by OSHA's access, and then they say you got to keep it for 30 years. But then they come back and say, it doesn't apply to vaccine records. You must maintain those records during the ETS. None of that makes a lick of sense at all, at least to Kentucky boy here, because you can't say that vaccination status is a medical record. Medical records are under OSHA, under the Code of Federal Regulations. You must maintain these medical records for 30 years, but vaccine is not a medical record that must be only maintained during the ETS and not for 30 years. That's a circular, one of those that just makes you kind of go, what are we supposed to do?
Hang on to them for a while.
I would hang on to them for a while.
Hang on to them for a while, and it'll be sorted out.
Right, and the thing that I see in here is I always go with the more specific to less specific. The more specific here is it has a statement in the ETS that says vaccine records must be maintained during the pendency of the ETS. That's the reality of what they want, but then they define those and tell you 30 years in different sections. At least maintain these throughout the ETS, so at least through May 22nd. We don't know what's going to happen, but I guarantee you in the next month, we're going to have so many updates to this. Everything I told you right now will probably change 3 times in the next month or 2. So hang on. ETS is not final. It is fluid. They can make changes to it. They can update. They can revise at any time without notice, without public comment, and without any notification to you. It literally is a mask mandate without being a mandate. It is also a vaccine mandate without being a mandate, because you're now allowed to fire people who don't get the vaccine. You are required to make people wear a mask if they don't get the vaccine. It is in essence what it is, what I told you they could not do under the law. That's why we have the challenges we're going to talk about. I anticipate updates that will include less than 100. This does attempt to restrict state and local laws and ordinances from being enforced. I see some real serious challenges. So here we go. Surprise! First one came, it dropped on Saturday the 6th of November. If you know anything about the legal system, they don't drop opinions on a Saturday. They drop opinions once a week. Federal Circuit Courts, that's one level below the United States Supreme Court. So you've had your first major court issue an opinion already to address OSHA, and it came out on a Saturday morning. The Fifth Circuit granted a stay. So everybody here's going, woo, all right, yay, we don't have to worry about it. Yeah, not so quick. The Fifth Circuit is Texas, in that area, Oklahoma, other areas around there. It does not apply to Kentucky. Kentucky is Michigan. Kentucky's in the Sixth Circuit, which is Michigan, Tennessee, Kentucky, and Ohio only. So the Fifth Circuit issued a stay. It assists in those states that are in the Fifth Circuit. It does not affect the Sixth Circuit. Not a final ruling. It is a temporary injunction pending a final ruling. In one of these cases across the country, Fifth Circuit wrote, and this is the big part of it, the pending lawsuit raised causes, I have a typo there, but it caused to believe that there are grave statutory and constitutional issues. That's critical because the only way that an emergency order can be issued by a court without the full matter actually going through the process is if there are grave statutory or constitutional issues of the level that makes it so unlikely that it's an enforceable law that the court must weigh in now to stop the process. The Fifth Circuit was the first one to see it. You're going to see this week, I would say, 3 or 4 other circuits. You remember I called the Ninth Circuit the Ninth Circus. I guarantee they will, I won't guarantee, they probably will adopt it and say that nationwide that there's no ability to challenge this because it's so awesome. Why? Because they always do. The Fifth Circuit is more conservative. They came in and said this is absurd and you can't do it. There will be all over the map. Just so you know, this is stayed until further notice. It ordered the parties to submit this week further briefing about the validity of the ETS. I'll be checking into that. 26 states have filed suit challenging the ETS. Kentucky joined a lawsuit similar to the other large one with Tennessee and Ohio because that's the Sixth Circuit. Michigan didn't join. Politics comes into play as to which attorney generals are running which state. You can tell which one didn't join, Michigan, which attorney general would not be doing that. So that's the lawsuit that's coming in. Substantial guidance is going to come in from all of these, and it's going to be all over the map. So here's what I have. There's a coalition of lawsuits: Missouri, Arizona, Nebraska, Montana, Arkansas, Iowa, North Dakota, South Dakota, Alaska, New Hampshire, Wyoming, and 5 additional private entities filed a lawsuit in the 8th Circuit, which is in Missouri, St. Louis area. They argued the power to compel vaccinations is not with the federal government, but with each state, which is surprisingly what I told you last January. Another lawsuit was Texas, Louisiana, Mississippi, South Carolina, and Utah in the 5th Circuit. That's the one I just talked about. Florida, Alabama, and Georgia filed in the 11th Circuit. Kentucky, Idaho, Kansas, Ohio, Oklahoma, Tennessee, West Virginia, and the 6th Circuit. So there you go. 26 states all across the country. It's a nightmare. Here's the problem right here. Until this litigation is concluded, which will not happen until the Supreme Court weighs in, because every circuit's going to have their own opinion that governs their few states. Until the United States Supreme Court actually rules on this, which could take up to a year, unless they issue a stay, all employers must continue to prepare for this, because this must be implemented by December 5th. Vaccines must be given by January 4th. So unless the 6th Circuit comes in and says Kentucky does not have to comply with this, you have to start now. So you're required to determine vaccination status. What's the proof that's required? Here are the answers I wanted to walk through with you before we get to everybody's questions. Acceptable proof includes a vaccination card, records from a pharmacy or healthcare provider, quote, or any other official document that includes the date and type of vaccination, the place that they received it. The problem is we've literally got EEOC, CDC directives saying don't require official documentation because that slows down our medical care providers, and we don't want employers slowing down medical care providers. How do those two things coincide? We still don't know, because the CDC literally says do not mandate official documents. The EEOC has told you do not require an official document. Now you're under an ETS that says get the official document. Which one do you want to follow? My recommendation is the one that has a $14,000 penalty for every employee, which is the ETS. So you need to require an official document. We don't know what this definition is of an official document, but I'd err on the side of caution, because you're being required to maintain these medical records with a log sheet of every employee, what you have and what documentation you relied on. So there you go. If they're unable to produce it, an attestation, which includes the following, is acceptable: vaccination status, full or partial, if possible, information regarding the type, the date, and so on. Here's the recommended statement. I declare that this statement about my vaccination status is true and accurate. I understand that knowingly providing false information regarding my vaccination status on this form may subject me to criminal penalties. These are federal criminal penalties, and if you've seen any of the fake vaccination scams that are out there, people that have gotten caught up, the FBI is involved. So if anybody signs this, it's more than under penalty of perjury. This is literally saying the federal government has control under OSHA, and they're going to be responsible for compliance under OSHA or criminal penalties, not just civil, not just OSHA. So federal government coming in with the full weight, which is again another question as to whether they have that full weight. Each employer is responsible for assurance of compliance. So copy this section down. Whoops, sorry. I was going to copy it for you. I'll do it here in a minute when we stop the thing, and I'll put it in there. But this declaration you need to have in there, and the statement from each employee you need to have as specific as possible. Don't fudge on that because the federal government's coming. So I warned you about the fact that the federal government was going to be much more stringent with employers, much more union and worker friendly, and much more willing to go after everybody. This is implementation at $14,000 per employee. So, and I know I saw a question in there, is it really 14 per? That's how it's being interpreted. It's not just 14 for not doing it one time. It's literally every employee is being endangered, so they're going to go after you for every single employee. At least that's what's out there. Compliance, December the 5th, not January 4th. I kept seeing that on all the news reports, and it's like, you don't have 2 months to implement. You have 2 months to get the vaccine. You have 1 month to implement, 1 month to get the vaccine after that. 60 days total, but they're expecting implementation to start November 5th with full-blown in place December the 5th and full-blown compliance January 4th. There you go. All right. Do I have to pay for my own testing? Yes, if testing is required, who pays for it? ETS divides unvaccinated into 2 categories. 2 people, or 2 types. Employees who report to the workplace at least once every 7 days must be tested at least once every 7 days, unvaccinated people. Employees who are working remotely and occasionally report must be tested within 7 days of coming into the office. The bizarre thing with that is, it doesn't say 7 days prior, so a person could come in fully exposed, expose everybody in the office, go home, be tested 7 days later, and say, oh, by the way, you remember when I was in the office last week? I was positive, everybody go get tested. It doesn't seem to help with it. I'm not positive as to why it says within 7 days. It should have said 7 days prior to report, but that's what you get sometimes when you're looking at sausage being made live. Documentation must be provided to the employer. The employer must maintain the documentation. It is a medical record that has to be maintained, at least for the extension of the ETS. So be prepared to document this every single week once you verify that somebody is not vaccinated. If the employee does not produce a test or that employee tests positive, now these are unvaccinated employees, that employee is not permitted in the workplace, period. It's not a, you may, not anything. If they don't produce it, you can't allow them in under the ETS standard. It allows the employers to require the employee to pay for the cost. We talked about this a couple of months ago under CDC, OSHA, EEOC. They were all already saying you can require employees to get tested multiple times in a week, and you can force them to be required to pay for it. So that's, that's been out there. Problem is, make sure it does not reduce them below minimum wage, and you darn well better make sure you check, especially if you have an office in Indiana, because Indiana has 2, I've talked about them before, 2 different wage and hour protections under their statutes and their laws that require ongoing agreements from those employees each and every time you deduct it from their paycheck. So if you're going to do it, make them go do it on their own. Don't do wage deductions in the state of Indiana, because that could get you into serious problems. All right, you may voluntarily pay for testing and may require more frequent testing. That's at your own insistence and agreement with any of the unions or bargaining agreements or individuals as you so desire as the employer. Record keeping requirements. We talked about this a little bit. You must keep record of each test result that you obtain. Put it in the red file because they are medical records. Don't allow them to be disclosed or discussed. Don't talk about results. Must be kept at least for the ETS. As I said, it's a medical record, so it actually is 30 years plus. Maintain the following records must be produced to the OSHA upon request. Any employer, anyone with written authorization consent from the employee is entitled to his or her COVID vaccination results. Within 4 hours of a request from OSHA, you must produce a copy of the policy. Any other records must be produced by the end of the next business day following the request. This is a very serious requirement. If you violate it, you're looking at those sanctions, $14,000 per on every request. So producing these to OSHA within 1 day for large businesses is a pretty shockingly quick result. As I said, that's why I would have it red file, but red file OSHA. Whatever color you got to do, because if you got to grab it quick, you better have it quick and not give them the whole red file, which might result in other investigations into other things that you never even thought they'd look into. The ETS impact upon OSHA technically requires it for the term plus 30. I already talked about that. Requires vaccination only for the ETS, but it is confusing. Types of tests that are acceptable. They're now allowing over-the-counter. It may not be both self-administered and self-read. That creates a problem because who's going to read the results for the employee wanting over-the-counter? Must be proctored over-the-counter. Point-of-care tests and tests where specimen collection and processing is either done or observed by the employer. In other words, they don't want a self-reporting by the employee so that they can say, yeah, no, I did it. Here's my result, and I'm negative. They want a third party involved or the employer. Keep in mind, I told you back in June, EEOC said, sure, the employer can do their own test, but don't, because if you do, it is a medical test. If you ask the wrong question, it is HIPAA. If you do the wrong thing, it is GINA. We highly recommend you don't do your own test. That was their recommendation. Now, this is saying you have to do it or observe it or have it done in a third-party point of care. You can require the employee. I would just have them go to one of the drive-through testing. The problem is a lot of the drive-through testing places have now closed down. This will probably reopen several of those because this is going to require testing all the time again like we were a year ago. So, are you required to give paid leave off for vaccination or testing? Yes, you must provide up to 4 hours paid leave for each dose of the vaccination. Reasonable time and paid sick leave to recover from the side effects must also be provided. That's what this bullet was. I was going to move it down here. That's me trying to make the changes this morning as I was headed. Sorry. You also must provide sick leave to recover from the side effects. So here we go again, guys, with the EFMLEA. It's not EFMLEA. It's not technically, I mean, it basically falls under FMLA, but it's now OSHA driven. If an employee who has not been vaccinated now gets vaccinated because of the ETS and then says, I now have side effects, now you have to pay them because they may have a side effect that allows them to be not in work. So welcome to the circus that we had a year ago. We're kind of back into it without a whole lot of structure or guidelines because you have to pay for it, but it doesn't say whether you're getting reimbursed. It doesn't say how this all gets done because there's no backfill now of the EFMLEA and the other protections that were available. So it's going to flesh out, but we'll see. Are you required to report positive tests? You must require employees to report those regardless of vaccination status. That's part of your written program, so remember that. If they test positive, they have an obligation to report it to you. It's not just the unvaccinated. They all have to. Employees who test positive must be removed. Employees are permitted to return only after receiving negative test result, meeting the Centers for Disease Control return to work criteria, or receiving a recommendation from a healthcare provider following allowing a return to workplace. So again, this is an ETS without a lot of regulation behind it that tells us how we're supposed to do this, why we're supposed to do it, when we're supposed to do it, etc. But it literally says, and whether they're supposed to be paid while they're gone. You do not have to pay unvaccinated. They say that elsewhere. But what about the vaccinated who test positive and how we're supposed to handle it? PTO, since we're on the subject, information about collecting and hospitalization reporting. You're not required to, under the ETS, provide paid time off for anyone removed due to a positive. We don't know what's going to happen with some of the other protections under not the infrastructure bill. We didn't have time to get into that today, and there's a lot in there as well. But it doesn't stop paid time off under other circumstances by collective bargaining agreement, again, the union, or any other laws that may be out there, again, left over from before or new ones coming in. Covered employers must provide employees with the requirement of the ETS, the policies the employers implemented, the CDC document entitled Key Things to Know About COVID-19 Vaccines. You must provide that to all of your employees now. The rights under the whistleblower protection of OSHA, record-keeping regulation, which prohibits retaliation when an employee reports a work-related illness. You have to now give them that as part of the policy, and the criminal protections and provisions under OSHA and other federal laws. So all of that has to be in your policy, which is why I said, you got to start now. Implementation is December 5th, and you can't sit there hoping, crossing your fingers, that the Sixth Circuit comes in and says, you don't have to worry about this law, let's wait on it. Because we don't know what the Sixth Circuit's going to do until it does it, and then the Supreme Court could literally smack it down the next day and say, no, we're going to let this go forward. No emergency relief from the Sixth Circuit, Fifth Circuit, 11th Circuit, or anywhere else, and you're required to have implementation immediately under the federal law. So don't wait. So when must you report fatalities and hospitalizations? Fatalities are within 8 hours. Hospitalizations within 24 hours. Both of those are new because you must report that within 24 hours of learning of the hospitalization. Previous ones, the record-keeping requirements required hospitalizations to only be reported if the employee was admitted to the hospital within 24 hours of exposure. Now it's your knowledge of it. Again, this is a nightmare because if you have multiple employees and people are just saying, I got COVID, are you supposed to report that even though it didn't happen at work, even though they weren't at work within the 24 hours? The answer right now appears to be yes. All hospitalizations must be reported within 24 hours of the employer learning of the hospitalization. Not of exposure at work, not of any trigger event, literally 24 hours. I suspect this is going to be fleshed out. I suspect it's going to be shot down. I suspect there's a lot of issues. And right now, all of you that had hair when you started, if you are in this category, half of it's been pulled out. I'm in the same boat because I'm trying to give guidance to people. And I have a feeling you're going to do some guidance. It's going to be tweaked 2 weeks from now once the circuit courts have weighed in. Then the Supreme Court's going to weigh in. Then we're going to either tweak or change altogether. But these requirements must be implemented before December 5th. Get yourself a well-educated attorney to help you walk through it. I would not trust just doing this because you're in the HR and you've been doing it for years. If you do that, make sure you know it all, make sure you've read it all, and make sure it dovetails with all of the other laws. Because we've talked about them for a year. EEOC, OSHA, CDC, the regulations, NLRB, that applies to most companies larger than 100 employees and less. You've got to deal with unions, you've got to deal with potential unions, you've got to deal with all kinds of things. Make sure you're careful with how you do it. Face coverings, we kind of covered this a little bit before. It's while they're indoors in a vehicle with a coworker, face cover is then defined as 2 or more layers of fabric secured to the head with straps or ties covering the nose and mouth and solid with no slits or holes. Face mask is separate. The reason why I hesitated there is 2 or more layers. Sooner or later, we're just going to be sitting there with gas masks on. But the face mask is a separate surgical or medical mask. Respirators also defined and excludes the face coverings of masks. Remember the N95 masks that have the exhale, and I see all kinds of people wearing them. Like it's like literally the worst thing you can wear for other people because it's projecting it out, but it's it. So face, this is the other part that causes some concern. This is the red letter. Face coverings must be worn by unvaccinated unless they're alone in a room with floor-to-ceiling walls, door closed, for a limited time while eating or drinking when the employee is wearing a respirator or face mask, which is bizarre, face covering unless they're wearing a mask, okay, I guess. Or if the employer can show that wearing a face mask is infeasible or causes a greater hazard. I would not challenge that at $14,000 per. You must permit employees, these are the vaccinated or unvaccinated, you must permit them to wear a mask even if the ETS does not require it. If they're vaccinated, they must be allowed to wear a mask. You cannot stop people from doing so. The concern there is if you, right above, it talks about where the work requires, where it may cause a greater hazard. That creates a problem then if you are then mandated in a different section to allow them to do so, even if it causes a greater hazard. So I don't know what they're going to do with that incongruence there. So who must pay for it? It does not require employers to pay for it. It notes that payment may be required under other laws, but then if you remember the EEOC said you had to pay for it, other laws said you had to pay for it. So kind of all over the map again as to who has to pay for it. My recommendation is require it, get the cheap ones paid for it. They're everywhere. I would just do it. What about state laws? What about local laws? Preempts all state and local laws that prohibit vaccination and testing mandates or face covering requirements. An employer can comply with both the ETS and state laws prohibiting vaccines by allowing testing right now. As OSHA explains, the rulemaking record prohibiting vaccine mandates frustrates the overall regulatory scheme. So they're basically cracking down on state and local laws. Chances of you complying with local laws if they are contrary to this, unless the Supreme Court weighs in, are zero, because this is literally intended to preempt. All right, states with a state OSHA plan approved by federal law may adopt standards that differ from this, so long as they are as effective or more effective. They cannot go below it, because it is not, remember this is a floor, not a ceiling. You can't say that you want to do something different unless it's better. So, must the state adopt it? The answer is yes. Every state must adopt this standard or higher. You can't go lower. It could have been effective immediately, but they expect that the ETS will result in approximately 23 additional individuals becoming vaccinated. Why? Because 1/3 of the country has not been. This affects 84 million people. 23 is really close to 1/4 of 84 million people. So there's their announcement. All right, next to last slide. Write down the next one, but these are the dates you need to know about. ETS is effective upon publication. That was November the 4th, November the 5th. To be in compliance, you must have within 30 days of publication all requirements other than the testing for the employees or the vaccine in place must have been completed, okay? 60 days, January 4th, all testing for all employees who have not received all of the doses required must be provided. So 2 different dates. The reason why I put this on the last slide, I know it's repetitive. I literally want to make sure you understood. You have to know 2 dates right now. 3 if you want to count the one that passed. They adopted it on November the 5th. You must have all of your requirements in place by December 5th. You must fully implement and require all proof of testing, all vaccination records, all red file, green file, whatever you want to call it, OSHA documentation must be maintained on the 4th of January. Those are the 2 dates you must make sure are in place. Let me answer the last question first. Rachel just asked a question about medical facilities. Medical facilities are not required to follow this ETS because they have their own ETS, which is more stringent. There is no testing out. There is no ability to exempt out. You must have your vaccination to be able to do it. I didn't have time to go through the medical. Pull up OSHA's medical ETS. They have a whole different standard for the medical industry, which is basically, and please don't quote me on this, the OSHA medical is, if you're in the medical field, get your vaccine. If you don't have your vaccine, you can't be in the medical field. I know that's a super simplification. I know there are exemptions to it, but they're trying to make the exemptions literally non-existent to the extent they can. This is the lesser, if you just want to know how stringent it is, what you just heard is the lesser stringent. The more stringent is the medical standard. You know, there was a lawsuit in Texas in the Fifth Circuit, went up to the Supreme Court, was denied for emergency relief, where there was a group of hospital workers that said, we don't want to be vaccinated because we have natural immunity. We don't want to be vaccinated because we have other issues, and we want to be excluded from that, and you're forcing us to do it. And the Fifth Circuit said, we are not going to intervene. And the Supreme Court said, we're not going to intervene. Supreme Court did a similar thing in the Seventh Circuit with the University of Indiana, requiring all students to be vaccinated. The Seventh Circuit said, we're not going to intervene. Supreme Court said, on an emergency basis, not a ruling on the merits, we're not going to intervene. I know of one in Michigan right now because we've been asked to assist in Michigan with a vaccination of a student who was banned from the campus, even though they were all remote and wanting to do remote work on campus, and they got banned from being a student in their last year trying to graduate. And not sure what the status is on that because the Sixth Circuit has not yet weighed in, but that's going to be another one. I know there was one in the 11th Circuit, which is, I think, the Florida, Alabama, Georgia area, where there was another challenge to voluntary or mandatory vaccination for a state institution. And the Supreme Court said we're not ready to address that one yet either. So right now there's a lot of challenges to the mandatory, but there's no relief in sight for businesses trying to figure out where do I go with it. So there you go.
All right.
Pregnancy vaccination, really good question. Really bad answer. I don't know, because the EEOC says make sure you give people alternative measures that they can do. There's been some studies that have said, I'm not weighing in, so please don't start comments saying, yeah, but you're wrong. There have been studies that say that pregnant people will not be impacted by the vaccine. I've seen other studies that say you shouldn't get it if you're pregnant, all over the map. EEOC says you must provide an accommodation. The ETS doesn't really talk about what to do with people who need the accommodation. It's one of those glaring mistakes when you try to rush out an emergency temporary standard. I say that after 11 months, but it's clear that they didn't cover every contingency in this. They should have. In that instance, if I were the employer, I would go with the EEOC standard. I would give that employee, whether it's a medical disability, whether it is a pregnancy, which, by the way, I don't know whether I've told you all this, I think I have. Pregnancy by itself is not a disability. So pregnancy does not fall under the Americans with Disabilities Act. It only falls under the ADA if the symptoms of the pregnancy are recognized as a disability under the Americans with Disabilities Act. The pregnancy itself is not. It's why we have other protections available that started to come out in the 90s and the 2000s for pregnant workers to protect them, because pregnancy by itself is not protected as a disability. So to the person that asked about the pregnant, if you're the employer, please go with the EEOC and figure out a way to give that person alternative relief. Allow them to wear the mask, allow them to be tested every week. Don't mandate the vaccine. Right now they're allowing the exception being testing every week. If they can't wear the mask due to medical and they get a doctor's note, put them in a room by themselves, or better yet, if you could figure out a remote environment for them, put them in the remote environment. There have been some really bizarre recommendations in the last couple of weeks. I think Tyler touched on it last week as well, where they're actually saying, you know what, put them in a different position altogether. If you have a janitorial position open, put them in a janitorial. And I'm like, wait, that's like the antithesis of discrimination because you're not supposed to change jobs based upon somebody's protected classification. You're not supposed to place them in a lesser position because you have one available. And yet one of the recommendations was, just put them in any job you have until this is done. And I'm like, what? That goes against everything I've instructed companies to do for the last 25 years. And yet that was literally a recommendation for trying to get around it. All right, let's, Lyle, anybody, will roll through every question everybody has until there's nothing that goes on. Gina, with the natural immunity, let me just touch on the natural immunity. Absolutely not one reference whatsoever to natural immunity, which is a big frustration for a lot of people because natural immunity actually could be stronger than the vaccinations that are fading at different times. And yet there's not any information among anything right now. Private institutions started some studies to try to prove the importance of natural immunity, i.e., to those that are wondering what I mean, those that have had the COVID and have recovered from it have a very strong natural immunity. There are 0 studies out there being funded by the government as part of the warp speed or anything else. So you have some private groups that have banded together to try to do those studies. The problem is they're not quick enough to get implemented as part of the law. And there's no ability for you to prove either, oh shoot, that was a shoot. I went blank on it. The testing in your body, the genomes to see if you have antibodies, see if you built up antibodies as part of the natural. There's nothing in here that allows you to present that as evidence of the fact that you don't need the vaccine because you have the antibodies or anything else. So there's nothing in there about antibody, natural immunity or anything else to help. Sorry.
Allison, were you going to say something? Can you help him organize these questions? Because there are a lot
Yeah, so
of
I've been trying to put them into categories and remove any that we've already covered in your session. So if you want, I can run through them. And I apologize if I do ask what you already covered. I was there were a lot of questions this time, so wasn't able to.
All right, let me just tell you this. If somebody gets too close to me giving one-off legal advice, I apologize ahead of time, but I have to be careful that I'm giving group presentation guidance in a human resources setting, and I'm not giving legal advice to one organization. So if you get too particular, too technical, you may have to get your own guidance, and I apologize, but that's kind of the way we have to go. So with that caveat, I will also say this. I'm drinking from this is a phrase I use, I'm drinking from a fire hose because this is literally changing by the second. Updates are coming in through my emails. Updates are coming in from courts all over. So I don't know everything. I'm trying my best to help out. And so this is the best we could do over a weekend with an announcement that made, in some aspects, very little sense. So if I don't know the answer, we'll try to get you some information. I have a feeling that we may be going back to weekly updates with how much of this is running rampant right now. So you'll probably get updates next week or the week after. All right.
Okay, so if a company is a federal contractor and receives federal money from grants, does that mean they have to follow the OSHA standards regardless if their employee size is 100 or more?
Well, yes and no. Actually, you are already required, and Tyler covered this a couple of weeks ago or last week. You literally were already mandated under the federal contractor executive order that got signed by the president, except there's a provision in the federal contractor, and I'll admit to you, because I was focused on this, I didn't go back and look at that. One thing, the federal contractor actually applied to new contracts. It did not apply to existing contracts unless those existing contracts allowed the federal government to include additional mandates. What I would do if I were you and you're a federal contractor is take a look at your contract. And I've done a lot of the federal contract work. Those contracts are a nightmare. They're a mess. They usually are overbearing, so get some guidance on them. But if it's a new contract, all new contracts require mandatory vaccinations in compliance with the executive order. This is the basement. So what it said in there is unless you're already doing vaccinations, and it was on the one of these slides up here, this one. Federal contractors covered under the Safer Federal Workplace Task Force COVID-19 Workplace Safety are not required to comply with this. All other workers are. So to answer that question, here are your only exemptions. So unless you're already actively doing the Safer Federal Workplace Task Force COVID-19 Workplace Safety Guidance for Federal Contractors and Subcontractors, you better be doing this. I'll go a step further. If you're trying to operate under well, our contract was signed in 2019, so we don't have to do it yet, you're not in compliance with this, is how I would interpret that, because you're not doing this mandatory guideline. So if you're not doing this being this second bullet, you need to do this ETS as your basement, because it literally says this is the basement floor. This is not a recommendation. So at minimum, you have to be doing this. The federal contractor was actually a step up off of this because the federal government has the ability to control federal contractors more than it does your everyday employers.
Okay, great. And then for size, do we have much guidance on, if a company has multiple fine numbers, do we treat them each separately, or is this based on a control group, or is that still pending?
I lost where we are. I was going to put this back up on. There we go. Is that on the screen now? Hopefully.
Yes.
No, hold on.
Yeah, we see your side.
There you go. All right. So the question was what again? I'm sorry.
Yeah, if a company has multiple federal ID numbers, is each treated separately, or is this based on, should they count as one company as a control group?
It's a little bit into a legal issue where you may need legal guidance, but if you fall under the potential parent control, alter ego, for example, if you have 15 FEINs, but they're really all controlled with a centralized location, centralized office, or centralized ownership, chances are you're going to qualify as a centralized business. If you're truly 15 different separate entities, and each one of those is independent without much commingling of assets, HR resources, legal resources, common control, then they would independently be counted. But I'd be careful trying to play games with it.
Okay. And related to size, so do we know if part-time employees count as one employee each, or are we looking at full-time equivalents? And do you have any idea about temporary employees, if they count, or contractors?
Wow, that's a great question that I did not anticipate. I don't know why I didn't, because I'm always looking at FTE, full-time equivalent. And I was trying to boil down this had so much to it when I was trying to boil down the OSHA. I'm going to take this down since Lyle just put that up on the screen. I'm going to stop my sharing so you all can just see each other, us, whatever. I don't know the answer to that. And I should. So that's why I said, wow, great question, because that's one where I missed. I should have added that in as to what it means to have 100. Until you hear from me to the contrary, I would assume 100 means 100, whether full-time or not. While we're on this and I'm answering other questions, I'm going to pull right now, unless Tyler's on and he's answering it for me, which I don't know if he's on or not. I'm going to pull right now and see if I can find you the answer. So let's keep asking questions.
Okay. Let's see. Do we have any guidance into how the booster shot factors into this, if at all, yet, or is it only looking at vaccination, the Moderna, Pfizer first 2 doses?
What was the natural immunity?
No,
Okay.
if the booster shot plays into this at all yet, if there's been any guidance on that, or if it's only focused on the first fully vaccinated.
So far, and hey, if anybody has this, by the way, that they want to talk about the full-time equivalent and wants to put it in the chat, I am looking, and believe it or not, I'm not seeing any guidance on full-time equivalent in any of the guidance. So right now, it looks like somebody missed the mark at the federal government, and it wasn't me just missing anything. But I'm looking. It literally says 100 or more employees. It does not say anything about, here it is. It's 100 employee count is a head count, not a full-time equivalent calculation. So there you go. And so back to your question, are they taking into account, shoot, I went blank again. The booster shot. That's right. Is the booster shot getting, not yet, but I had Tyler last week. I didn't get to listen in last week because of where I was and what I was doing. But I sent something to Tyler to mention to you all, which is the next shoe is dropping. There's already a large company that has declared that everyone must have the booster shot by December 23rd or so. It was a date like that. That was up on the things I was getting information on. So none of that took effect yet on the ETS, but I'm pretty sure we're going to start to see a lot of information where the federal government is going to start to require you to take into account the boosters, which is why some of the people are saying, how is this fair? Because you know, you told us as long as we got the booster, we could get back to regular life. Now you're saying we don't need to, or we can't get back to regular life even with the booster. So, or with the regular shots. So I'm not positive what the impact is going to be. I do know that there's a tremendous amount of flux going on here. That's why I said this is very fluid. So stay tuned for the rest of it. I did put, somebody asked that the quote be in the chat about the declaration from the employee about getting things, getting their vaccination. So I put that in there. I know I'm looking at different screens and I apologize, but I'm trying to get all this information out there for you. The other part of that quote needs to be this, which is literally, if they can't provide an official document, they have to have at least this attestation about what information they're providing. And then the quote saying, I declare this statement about my vaccination status is true and accurate, blah, 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 criminal penalties. So keep rolling with the questions. I'm going to keep trying to throw things into the chat if anybody asks for quotes about things or anything else. I'm trying to multitask. You're seeing the ADHD coming out in me now.
So clearly we've established that employers are not required to pay for the testing, but the question is, do employers have any responsibility to pay for the time an employee takes to test or any type of mileage or other associated costs to get the test?
Not under the ETS. To get the vaccine, yes, up to 4 hours. To get the test, no. They can require the employee under the ETS to get it on their own time. The interesting rub here, if you will, is if you go back in time to when everybody was standing around waiting on an elevator or their interview for their Healthy at Work daily questionnaire and daily test, you remember I told you their time standing in line is in fact compensable time. It's called the donning and doffing, putting on, taking off of clothes, or something that's required by the employer before the day starts. Is this not a requirement that you're requiring them to get tested before the day starts? The answer is yes. Is this not then something that they must be paid for because it is something required by the employer before the employee can start? The answer is yes. However, you have a CDC, EEOC, and now an OSHA ETS that says because these are unvaccinated people, we're going to punish them. I know it's not what they say, but it is what they're saying. We're requiring you to get tested. We're requiring you to pay for it. We're going to require you to do it every week, and you're going to have to do it on your own time. To me, there's an inherent to pay for the employee's time while they were standing in line to come into work and answering all of your questions, getting their forehead temperature check, and have you been sick? Have you been this? Have you been that? Have you been this? You're supposed to pay them for it. Even if it's 3 minutes a day, you're supposed to pay them for it. Now they're telling you, force them to go get tested once a week, and it doesn't say anything that you have to pay for them. Which law controls? Unfortunately, you've heard me throughout this say more specific law controls, the less specific law typically doesn't. I would go with the EEOC here, I go with OSHA here, I go with this, I go with that. On this one, you have wage and hour that is very specific. You have to pay for it. You have OSHA, very specific. The employee has to pay for it because they're the ones not getting vaccinated. I don't know. I would be very careful about, I don't think under the ETS it expects you to pay for the employee to go get tested. I believe if you are challenged as an employer under wage and hour about, I didn't get paid for the time I had to go get tested when I was unvaccinated, I believe you'll have a pretty good defense under OSHA saying, we're not requiring you to pay for it. However, it's not rock solid because the law, the ETS was issued without the underpinnings of the descriptive law that says, unless employee this, or if employee that, and this overrides that. And what's troubling is it literally says right in it, it's not required under the ETS unless it's required under other federal laws or other federal regulations. Well, what the heck does that mean? Because you're literally requiring something that the other laws say you shouldn't have to require. So it's a mess. Can someone bring their at-home test, do it in front of their employer? Yes. I have a question in response to that question. I'm sorry, the question was in the chat. Can someone bring their at-home COVID-19 test and have it viewed by the employer as a third-party visualization? The answer is yes, unless the results were delivered outside of the presence of the employer, then no, because then the employee could have possibly tampered with and you don't have the independent third party. My question was this: so what if I go to my employer, my girlfriend, my boyfriend, my significant other, whoever it is, and I go to that person and say, verify the test results? It doesn't say in there, has to be somebody who is unrelated, unconnected, untied. It literally just says someone other than the employee. I know what the intent is, but again, sloppy without the underpinning of the law. They don't tell us can't be your best friend, your neighbor, your drinking buddy, the bartender down the street. Can't be your coworkers. It must be a medical person or an employer or an independent medical provider. That's what it should have said. They didn't say that.
Okay, can when tracking employee vaccination status, do you think it's acceptable to accept copies of cards, or do would we need to require originals, or else then sign that attestation?
There's no such thing as I know a lot of us have it. I have one. There's no such thing as a vaccine card. They're all different. So copies of cards should be sufficient. After all, they're allowing the attestation of the employee saying, I don't have the card, but I took it on approximately this date, and I believe it was this vaccine, and I've had both doses and blah, blah, blah. So I think a copy would be fine. The other thing I want to point out to you is there's a big blowback right now. I forgot to mention this. It was too much to put in the chat or in the presentation. There's a big blowback right now that the Johnson & Johnson is not being accepted at all by certain employers because they're now deciding that one dose is not enough by itself, and so they are precluding Johnson & Johnson. That's bizarre as well because the CDC literally adopted Johnson & Johnson one dose as one of the three that you had at your disposal to use, and yet now you've got employers saying, well, screw that, I'm not going to accept it because people are having to get boosters and Johnson & Johnson by itself is not enough, start over. I don't know what authority they're acting on, but Johnson & Johnson is creating a big mess because people are saying it's not effective enough, it's only a one dose, we want more doses, we want this, we want that. That's a big mess. The question about the third party being HR, could it be the manager? Absolutely should not be the manager if you can avoid it, because if you remember all the tests or all the discussions I've given in the past, If a manager is directly involved in receiving medical information, the manager could hypothetically use the genetic information or the medical information against the employee, and now you're into an ADA discrimination claim. I always talk about maintaining all medical records, including vaccination status, including tests, because those are medical records separate from the manager. Certain of you are so small, you're like, I don't have an HR, I'm gonna have to look at it. The answer to that is just be very careful with the medical information. Never be looking at the medical information while you're making an employment decision. Keep those separate from the employee's personnel file.
Okay. And clearly we've established that, the employer has to provide time and some paid recovery time for recovery from the vaccination. Is there any limit on how long we may be required to offer paid time off if an employee suffers ongoing side effects?
I didn't see anything in the OSHA. I won't say it's not somewhere tucked in the 1,000 pages of guidance that they're giving us. So don't rely on this as absolute, but I didn't see anything in there saying up to 2 weeks or up to a week or 3 days. It literally just says symptom side effects related to mandating the COVID-19 vaccination. Remember, you don't have to give them time off for the testing. 4 hours for the shot. It's up to 4 hours for the shot itself. It's not just 4 hours, it's literally up to 4. So if it only took them a half an hour to go get it, they don't get 4 hours. It's the time it takes them to get the vaccination. You're supposed to compensate them for that time, and then whatever the side effects are, but the underpinnings did not appear to be there for me. Okay, Cindy says in the template, it says two days. The policy template, though, is not the law. Policy template is just a suggested guideline or guidepost that you may be able to use. I'd be okay with using that, but what if somebody's symptoms go beyond that and the actual ETS does not say limited to 2 days? Now you're in violation of the ETS. So I personally did not see it in there. So stay tuned. We're going to be fleshing out these things week to week, I'm pretty sure. We're going to have to spend time boiling it down, reading the guidance, seeing what the laws, or what the courts have said. This is going to be a weekly or bi-weekly, because the ETS is the single largest thing to impact all of you since probably the PPP, if not the same size as the PPP, because this is more dangerous for you if you don't comply with it. And it's going to have more disruption on the supply chain, more disruption on your employees. This is a big deal. So I was pleased to see, Lyle, I think we had like 190 at one point, maybe a little more. I didn't see the top level, but I know we had at least 190 at one point.
Yeah.
You all need the help. I need the help. This helps me get geared up for talking to all of the people that I'm giving guidance to. So I'll stay here as long as you have questions. I know we're an hour and 20 in, but we covered a tremendous amount before the hour. What else do we have?
Oh, we've got all kinds here. Okay, when it comes to getting copies of vaccination proof, do we need to retain the copies, or once it's seen, can we record the information on the spreadsheet or in the log and get rid of those files?
You have to retain it on a log and in the file.
Got it. Okay, would you recommend we only have paper read files and not store this electronically?
Actually, I was going to suggest the potential of storing it electronically and not in paper. The only concern I had with that was I don't know what OSHA, and this is my ignorance of what they require. When they require production within 8 hours or 24 hours, I don't know if they require you to physically produce to them in paper or if they will allow electronic. And I just didn't know the answer to that. From a security, safety, confidentiality perspective, and for ease of pulling it up and delivering it, I'd rather have it be literally electronic only. but I don't know the answer to whether OSHA, and some of you probably deal with them more than I do because I just give the guidance on it. I give legal advice, but I don't like talking to the OSHA people. They scare me. So I don't know whether OSHA will accept electronic records in lieu of paper. I know the federal, like the IRS does now. For most accounting records, I'm allowed to keep electronic, except for certain, but I don't know what OSHA will allow. If you have less than 100 employees, you are not, I'm going to just answer this really quick, you are currently not required to adhere to the ETS unless you have a federal contract. However, the reason for you being on this, Jane, would be, or to whoever, is if you have less than 100 people, this could be changed with a second notice to apply to you. I don't know what the implementation deadlines will be, but an ETS by definition can be implemented without any notice whatsoever. So right now it does not physically apply to somebody with less than 100. That came through my private chat, sorry.
Oh, no problem. What if the employee cannot get an appointment for testing due to the anticipated high demand? Will they not be allowed to come back to work, and can we make that time unpaid?
It is not unpaid, or it is not paid. It is unpaid. They don't seem to care about whether it takes you time to go get shots because they basically say, we've made vaccinations available for a year, and if you haven't gotten it, it's your own fault. So unless somebody saw something different in one of the policy templates or something else, from what I have seen of OSHA, there is no suggestion of any relief because you couldn't get a timely shot. Besides, they're giving you until January 4th to be fully vaccinated. So they're looking at it right now going, you have 2 months to get vaccinated to go do it.
Oh, I think they were talking about testing. If an employee has to get tested weekly, but there's an influx of people trying to get weekly tests. Are they allowed?
The unvaccinated COVID test. I'm sorry.
No, my bad.
So the answer is no. If they don't have a negative test, we covered that on one of the early slides. If you don't have a negative test, you cannot show up to work, period. Literally, and I'll read it to you, the ETS divides unvaccinated into 2 groups. Those that are coming in routinely have to be tested at least once every 7 days, and those that work remotely and come in on an occasional basis have to be tested within 7 days of being there. And then finally, the last part was if an employee does not produce a test or tests positive, the employee is not permitted in the workplace. So it's not even your decision. The OSHA has literally said you can't allow them in. Doesn't matter whether they're waiting on the results, blah, blah, blah. OSHA doesn't care.
Okay, great. And with things tied up in the courts, what do you think the likelihood is that this will actually pass in its current form?
Okay, so don't rely on this because as we said at the outset, you still have to comply until you don't have to comply. I don't see any way at all this will ever be law the way that it is currently written. That's one person's opinion. It's one person's opinion that goes all the way back to January of last year. I literally told you I cannot fathom a way that they can do an ETS under OSHA that requires masks or vaccination because that usurps the state's rights, and the states have the right to control their own citizens. This goes beyond anything that we have with black lung, anything we have with asbestos, anything that ETS has ever tackled before. So I'm not asking you to rely on it, but looking at the challenges to it, to already have a Fifth Circuit Court of Appeals opinion that says we have serious concerns about the Constitution, which is states' rights, and statute, which is this doesn't even have the underpinnings to make it a law. In its present form, I do not see it being implemented. In some form, possibly. But what they've already done is they've gotten a lot of the large manufacturing and large companies to already adopt it. So it's already somewhat becoming effective because people are getting the vaccines because they're afraid of losing their jobs starting January 4th. in essence, by the time it is set aside, unless an emergency action is taken by the Supreme Court, a large number of people will already be impacted, including the supply chain. So there's your answer. And that's not, please understand, that's not a should it be, it's not a can it be, it's not a, if we change this to a better ETS, could we get it through? In its present form, I don't see any way under our Constitution for the federal government to mandate masks. That's why it never happened. I don't see any way for them to mandate vaccines. That's why it's never happened. And you can't use a vehicle, an administrative agency such as OSHA that's set up for the health, safety, and welfare of the working population as a way to end run the Constitution and to end run statutes of Congress. That's exactly what this is, because it's literally saying, unless you get the vaccine, you must be masked. Unless you're masked, you must have the vaccine. Those are, it creates some legal problems for everybody. Temporary workers, good luck with it. You're both employers. I represent a tremendous number of temporary staffing agencies, and under current statutes and current laws, both the temporary employer and the on-site employer are employers for all purposes related to the employee, including OSHA, discrimination, EEOC, ADA. You are both employers, you are both mandated, and you both have to have this policy in place, and you better start working on it together, because they cannot conflict with one another, because the employee has to comply with both. Contractor comes on site. If you are an employer with more than 100 employees and a contractor comes on site, I don't know the answer to that, because this does not cover contractor liability on site. In an employer that has more than 100, does that then start to impact your customers and so on? I would suggest to you that each contractor has to meet the threshold of 100, unless, to that question from Cindy, if you're a temporary staffing agency or that employee, that contractor is under your exclusive control throughout the day, so if you control their work, you control what they do, then you're a joint employer, then you are required to make sure they're vaccinated. If you don't control them, they have complete autonomy and independence, and they just are on site at your facility. They work for themselves, and that's different. Once you control hours, output, there's 14 different things that go into that. It's under the IRS regulations. If you're not an independent contractor, even if you're a 1099, in essence, if you're controlled by the employer, then the employer must provide the protections regardless of how you call them an independent contractor.
Okay. How do we handle employees who refuse both the vaccine and the testing and mask requirements?
Carefully. Under the ETS, you can fire them. Under the EEOC, you can fire them. Under the OSHA regular, you can fire them. Under the CDC, you can fire them. Except under EEOC, it says if you have the ability to give them a reasonable accommodation, then you can give them the reasonable accommodation if it's religious or disability related. And remember our definition of religion. According to the EEOC last January, they came out with a definition of religion, which is anything that is believed by the individual passionately. I know it's not what they say, but it's literally just anything that they believe, whether it's godlike or not, whether it's multiple gods, no gods, a belief in God, an absence of God, but they strongly believe it, then it's a religious belief. So I would be very careful with that situation. Get some guidance on that specific, because if they're refusing both and you cannot accommodate, I would document the heck out of the person's file that they are refusing it, the basis of refusal, the inability to provide any other workplace accommodations to accommodate them, and their refusal to wear the mask, which is their alternative to being vaccinated. And that exception to the vaccination applies, and I'm talking 100 or more, that applies also to those that are disabled, religious, they must wear a mask. There is no out for anybody unless they can do it at home, or those few things where they're in a room, floor to ceiling, closed doors, temporarily while they're eating or drinking, or more dangerous to wear the mask than not to have one because they have other things involved with their work environment.
Okay, we've had a couple questions just about wanting you to kind of go back to the enforcement. Basically, I think there was disbelief. Just did you say $14,000 penalty for not having the documentation? I just wanted to confirm.
Oh, it's more than that. If they wanted to count it as $14,000 per employee because you didn't provide it to each employee and you're required under the ETS to give it to each and every employee. So they're talking about multiplying this by the employee since you're mandated to give it to each one, or not having it for each employee upon the request from OSHA. That's how many violations is not one violation for not doing it. It's one violation per employee for not having it in each employee's record.
Okay.
It's
and
a
how does
nightmare. This is the concern I have.
That's like a new tax. Oh my gosh, that's huge.
That's what they're calling it.
how does this order affect public school systems? Do we know?
No clue. Public school systems are employers over 100 for the most part, so they're going to have to comply with it under that. They have their own standards as public schools. Unions will be able to handle this in excess of, but remember, it is a floor. So at minimum, unless you're in a very small school system that has less than 100 employees, which must be like really small counties, chances are you're going to be, this is your floor. You must comply with this.
Okay. And when we're talking about reporting COVID related stuff to OSHA, do we know, how are we supposed to know if a positive is work related? Do we have any guidance on that?
It didn't say it had to be work related. That was the big difference between this one and the last one. That's why I said this is like bizarre. It no longer requires that it be a workplace exposure like it did before. It literally says, as soon as you learn of a COVID-19 positive, you are to alert OSHA. I don't think that's what's intended, but you're looking at an ETS that's all over the map right now. And I could be wrong on first read of it, so, I'm trying to drink from a fire hose. It's very difficult, but from what I know right now, the OSHA directive is, as soon as you learn of a COVID-19, you're required to report it to OSHA.
Got it.
Period. Not workplace related. You must report it within 24 hours. I guess what they're suggesting is it could have happened at the office and then other people could have been exposed, so you better start reporting.
Mm-hmm.
Remember, those are vaccinated or unvaccinated. That reporting requirement, deaths and hospitalizations is what that was. I think that's the 24 hours of hospitalization. So it's not just reporting anybody sick. It was, let me make sure. I don't want to say this wrong. Sorry, 1 second. Yeah, employees who report positive test results regardless of vaccination status. Employees who test positive must be removed from the workplace. Employees are permitted to return, blah, blah, blah. But yeah, it was, you must report it if it's reported to you.
And we had some questions about how to report. Do we know if that's on just the annual reporting, unless it's a serious case like the hospitalization, or are we supposed to notify OSHA individually?
Let me find where that death was. Hold on. Try to find what page it was on so I don't misstate it. Okay, fatalities and hospitalizations. So you must report the fatality within 8 hours. All work-related COVID-19 fatalities within 8 hours. Requires any reporting within 24 hours of an employee learning of a hospitalization. Doesn't say work-related. So deaths are work-related. Hospitalization is within 24 hours. You must report it to OSHA. It doesn't say how, it doesn't say what form, and it doesn't say whether it's work-related or not. I think that's going to be fleshed out. I think we're going to have changes in the future because that does not make sense simply because somebody happens to test or be hospitalized and they're positive with COVID. It doesn't say that it has to be work-related.
Got it. Okay, and
yeah,
just
the comment from Valinda. Now you're seeing the problem with this new standard. OSHA is not set up to handle this many requests, this many reportings. You know, we have this contact tracing. We can't even contact trace. We have people who are positive and they never even get a call from contact tracing. Hospitalized, Gina, I misspoke. Report hospitalizations within 24 hours. You don't report every positive case, and I apologize. I misstated that.
Great, and then let's see. We have a large amount of volunteers that support our work weekly. Should we require vaccines for them?
No clue. And I hate to hesitate because I think I know even who that might be, but here's the problem. If you are controlling the volunteers, let's take a soup kitchen. You're controlling the volunteers. You're responsible for them making sure the food's prepped, it's delivered, it's organized. Then technically speaking, they are working for you. If they got injured, they would be entitled to OSHA or to workers' comp, except they're volunteering their time. There's certain waivers on volunteers, but this all talks about head count, and it does not talk about full-time equivalent or anything else. It literally is counting heads. My first gut reaction is if you're using volunteers to perform services on behalf of the employer, the chances are you're going to fall under it. Meaning you're going to be required to require those people to be vaccinated to volunteer for you. I'm not positive on that. That's really almost to the point of being a one-off where you need guidance because I haven't looked for volunteer exceptions and things like that, but I don't think the ETS is written well enough to include those types of qualifiers off the top of my head. I'm trying to be careful even what I say about it, but it's not very well written because it has a lot of internal conflicts that we've already pointed out even today. I'm very concerned with how you all can implement this without stepping on other laws, other provisions of federal law, because they say it preempts state law. So let's say, fine, you don't have to comply with state right now. There's enough federal law overstepped here that it's nearly impossible for you to comply with this and wage an hour and minimum wage and EEOC guidance that we just got 3 months ago.
Got it. Okay, we had a question. Is there any reason that you could not adopt a policy of requiring vaccination or test in the short term and then eventually move to a mandatory vaccination policy after January 4th?
Sure. Right now, the EEOC came out back in August and said, you can have a vaccine mandate if you want. And you can't. The only thing they said, and they had their little caveats and make sure you try to give reasonable accommodations, don't fire people unless you have no other way to accommodate them. See if they can even do a different kind of job. Maybe your accountant could be the janitor at the accountant's pay for 3 months. I mean, they literally came out with all these suggestions, not the accountant being a janitor, but it was, they seem to be, and we talked about that at the beginning of August. There was a push to change federal discrimination enforcement laws to encourage vaccinations. And it really troubled me because it literally was saying, we're going to hammer you on all this discrimination, unless, of course, we don't want to, then we're not going to hammer you because we want vaccination. So we're just going to look the other way. I'd be really careful with that because I could see that coming back the EEOC could change that on a dime. So just be careful.
All right, and we're down to our final two questions based on, I think you've answered a lot of them by answering other questions, but if anyone thinks we've missed theirs, please put it back in the chat. But is there a concern for letting the employee upload documentation, such as a copy of their card or their negative COVID test, or do we need to have that in hard copy?
I kind of answered that. I think you should probably have them upload that. My only concern in a secure portal, only they have access, only to the HR department, blah, blah, blah. My only concern related to OSHA's requirement and whether OSHA would accept digital records. I can't imagine they wouldn't, because it would be a lot quicker to look through the digital than it would to look through the paper. But I don't have right at my fingertips that they will accept digital records. That was my only concern. I would not have employees dumping a bunch of paper records on you all at once. If at all possible, I would gather those, worst case scenario, gather those in a secure environment and print them out securely if you had to have them in paper, because having a whole line of people with 100 or more employees coming in handing you vaccination status, vaccine cards, copies of things. Oh, I don't have a copy, or here's my original. I would have a secure portal instead of that, because that to me is scarier than anything.
Okay, great. And then do you care to circle back to employees that work outside? Do we think construction might fall into that, or what guidance do we have? I know you talked about it a little bit, but we've had some follow-ups.
What they said was exclusively outside. So the first thing I thought of was landscapers. I don't know about construction, because once you enclose the building and you've got drywallers, electricians, floor installers, carpet, finished carpentry, is that outside? No. But the framers are, the bricklayers are, the roofers are, the concrete layers are. So I look at it in terms of building a house. I don't know. I think if I were the employer, I would not take risks with the games because of the potential penalty per employee. So if you literally have people that are exclusively outdoor jobs, fine. If they start to be inside at all, and what says exclusively outside? So what if you have, and I was joking earlier, but this is the rest of the example. I said, what if I rip out the windows in my office, then am I outside? But then you have a bathroom that people go in, and it's an enclosed area. It's not exclusively outside. So even if I have construction workers, but I have a bathroom that's inside, is that exclusively outside, or is that now inside? Even a porta potty, is that a room? And now I have to have everybody vaccinated because there's an enclosed area that they have to go in to utilize the facilities? Or do I offer to I'm being sarcastic, but not, do I offer to my employees that you don't have to use the porta potty or the bathroom? You can literally use outside in a tree if you want. That way you don't have to be vaccinated. There are so many undefined terms in this. That's why I said when somebody asks, do you think this will ever get to a law? And my answer is, in its present form, I do not think so, because you can't define you can't have a term that says exclusively outdoor and then not define what that means. You can't have a term that says, we don't require you to pay for the time off to get the testing, but under this law, but you still have to comply with all other laws. That doesn't tell us a darn thing about whether wage and hour is going to require me to pay for somebody to be tested weekly or whether it's on their own dime. I know that they have to pay for the test themselves. We already covered that a couple of months ago, but the time to get the test is still kind of in a gray area. And those are the types of things they should not be. You shouldn't have a gray area when you have an emergency temporary standard that becomes enforceable immediately upon announcement on November 5th. Shouldn't be questioned, shouldn't be challenged. It shouldn't be something that we can't figure out what it means It should literally be black lung disease. You can't have people exposed to this. They must have the following masks on with regulators so they don't get black lung, period. Asbestos, you shouldn't allow people around asbestos without the following protective gear on, period. They don't have all these ifs, ands, or buts. It's literally, you can't allow people, if you test and there's asbestos, you can't be around it. If you're going down in the coal mines, you can't be around coal dust. You must wear the following respirator. You can't have people exposed. There's no ifs, ands, or buts. This one has so many ifs, so many ands, so many buts. It's mind-boggling how to try to build a policy that use their form policy. When you get sued, pull it out and go, this is the policy you told me to use. But then I'm not sure it'll even take effect 2 weeks from now.
Jim,
Yep.
let's think about wrapping this up, but I wonder if you could say, okay,
No, we're good.
a lot's probably going to change between this week and next week, but what should people do this week to get ready for next week?
Get your mind wrapped around the 4 documents you have to do. There's 2 things to do this week. I'm going to pull them up so I don't mess it up because I've read a lot.
Go for it.
Number 1, you have to have a policy in place 3 weeks from now. So start working on the policy that includes the requirements of the ETS and the policies of the employer that have implemented, that the employer has implemented to comply with ETS. That's number 1. Pull down the CDC document called Key Things to Know About COVID-19 Vaccines. It's on the CDC website. Have that ready to go as part of your policy. Pull down the whistleblower rights for the employee. Have that ready to go as part of your policy. And have the statement pulled down about the criminal provisions of OSHA that preclude threats and violence against people and falsification of vaccines and so on. Have those 4 things pulled down, ready to go. Start massaging a policy, pull down their sample policy if that works for you. Have those ready to go. And write down the following 2 dates. December 5th, policy implementation. January 4th, vaccination implementation. Have those dates on your calendar, no ifs, ands, or buts. And the other thing you have to do, and I'm not being silly here, come back next week or the following week when we have our update and see how the law has changed to impact that policy. But if you have those 4 things pulled down and those 2 dates in your calendar, we'll get you through it as we walk through the ever-changing minute-by-minute updates to these policies. That's it.
All right, there you have it. Allison, anything else? Final word.
Nope, I think we've got all the words.
Final word, as long as it's not a question. All right, thank you all so much for your great input. Oh my gosh, so many good questions and the good feedback. So everybody have a great week. Keep smiling, stay safe. Let's get back together soon. Thanks a lot. I see a lot of comments coming in. We appreciate it.
Thank you, everybody.